Item number 4, my lord. In this case, I'll be filing my reply today. Matter may kindly
Today?
take, yes, matter may kindly be after a week, my lord. I'll be on the other side.
Mr. Adi, Learning Counsel for the petition has submitted that and affidavit in reply of the petitioner is going to be filed during the course of the day. He has thought, with the consent of the learned counsel for the respondents, or listing of the case after a week with the affidavit on reply on record. Post of apprised out is that it is after a week with the affidavit on reply, affidavit in reply of the petition on record.
May I please, your lordship? Lordship, in item number 14, lordship, we filed one rejoinder affidavit, lordship. So that may be called for, lordship. Deeply obliged.
Wait, please, your lordship. I beg to mention for a listing matter for admission.
We give it to the court master.
Obliged.
Supplementary list for withdrawal, item 17.
May it please, Lordship. Lordship, I may be allowed to withdraw the petition, Your Lordship.
Your name, please.
MD A. Rahman, Your Lordship.
Mr. A. Rahman. Learned counsel for the petition has submitted on instruction that the petitioner wants to withdraw the petition. Mr.
S.A. Munir.
S.A. Munir on behalf of, okay, learned counsel for the respondent number 8. And Mr. J. Hindick, learned junior Roman advocate for the state respondents of the in view of the above submission made by Mr. Rahman, learned counsel for the petition. The petition is dismissed on withdrawal.
Lordship, there's an interim order that may be vacated.
The interim order. Past alia stands recalled.
Much obliged.
Bad piece of watch. My lord, the issue involved here relates to settlement of some government land in favor of the petitioners, which they are in occupation since 1975. Meanwhile, a few round of litigations up to this honorable court, and thereafter the matter was sent for consideration of the authority. The authority rejected it finally. That's how that final order has been put to challenge again before this honorable court. Before I take your lordship to the impugn order, I would like to take your lordship to the judgment and order of this honorable court passed on that annex 4 maybe. I don't know about what's this one, give order to. That is Ranjan Gogol. Yes. At page 38, lordship will can be turned to. Annex 6. This has crystallized the whole thing, and thereafter further development, how to go about, that is required to be seen. Should I read it, my lord? Lordship will kindly page 38. Heard so and so. Para 2. The writ petition has been filed, praying for a writ of mandamus directing the government to pass an order for settlement of 7 bigha 1 katha 17 lessons of land situated in village Poshim Jaroni, Moja Nomati, in the district of Nagaon in favor of the petitioner. There is no dispute that the aforesaid land is Sarkari land and the petitioners are in occupation of the said land since 1975. A perusal of the contents of the writ petition would go to show that from time to time notices of eviction were issued against the petitioners, and several litigations has erupted in respect of the aforesaid notices, including appeal to the Board of Revenue. This court has also been moved on an earlier occasion as a sequel to the orders passed by the authorities in the matter of eviction of the petitioners. Subsequently, simultaneously, with the challenge against the eviction process, the petitioners have, in view of their long occupation of the land, filed applications for settlement of the land in accordance with the government policy in this regard. The amendments made by the writ petitioners and the documents endorsed to the writ petition would go to show that such application for settlement have been duly processed by the authorities of the state, and in fact, the Land Advisory Board, HOSAI, recommended settlement of the land in question with the petitioners on 12/1/1996. The aforesaid fact would be evident from the document enclosed as Annexure 8 to the writ petition. The petitioners have averred in the writ petition that the aforesaid recommendation of the Land Advisory Board, which was to form the basis of further action by the state government for settlement of the land in question, was arbitrarily cancelled without notice. The aforesaid cancellation of the recommendation being allegedly at the instance of petitioner respondent number 4, that private individual, an ML at that time, and without giving the petitioners any opportunity of hearing, is therefore amounts to that is not contempt, it is wrong. It amounts to, let me just read the correct word here, in the page, actual photocopy.
Yes.
The correctness of the documents enclosed, yes, I'll be referring to page 43, that is photocopy. Lordship may come to photocopy, that would be correct. Here typographical mistakes are there.
Page?
Page 43. That judgment of the Honorable Justice Ranjan Gogoi. Here, is 42, Lordship will say. 42 I was reading. Eviction of the petitioners. Simultaneously with this challenge against aforesaid notices, including board. In view of their long occupation at the middle of paragraph 3, my lord, page 42. I'll read from there. In view of their long occupation of the land, filed applications for settlement of the land in accordance with the government policy in this regard. The amendments made by the writ petitioners and the documents enclosed to the writ petition would go to show that such applications for settlement have been duly processed by the authorities of the state, and in fact, the Land Advisory Board, HOSAI, recommended settlement of the land in question with the petitioners on 12/1/96. The aforesaid fact would be evident, that should be evident, from the document enclosed as Annexure 8 to the writ application. The petitioners have averred in the writ petition that the aforesaid recommendation of the Land Advisory Board, which was to form the basis of further action of the state government for settlement of the land in question, was arbitrarily cancelled without notice. The aforesaid cancellation of the recommendation being allegedly at the instance of respondent number 4 and without giving the petitioners any opportunity of hearing is therefore likely is therefore considered to be ex specie bad in law. Maybe, my lord, this is considered. Considered to be ex specie bad in law. Admittedly, the Land Advisory Board of the of the district on the basis of whose recommendation the state government is required to take further action in the matter of settlement of the land had recommended the case of the petitioners. The correctness of the document enclosed as Annexure 8 to the writ petition has not been disputed or controverted by the state by filing an affidavit. If the cases of the petitioners for settlement have been recommended, such recommendations vest in the petitioners a legally enforceable right for consideration of their cases for settlement. Lordship may kindly mark this portion. The subsequent cancellation of the recommendation is admittedly without notice and more glaringly without any reason in support thereof. As to what eventual decision the state government would have taken in the matter is not for the court to speculate at this stage. It will be suffice to say that action on the basis of the recommendations of the Land Advisory Board, the state government was expected to pass final order in the matter of settlement of land as claimed by the petitioners, keeping in mind the principle of fairness, reasonableness, and entitlement of the petitioners for such settlement in view of their long possession. In the above noted facts of the case, treating the said recommendation as valid, my lord, kindly noted. Keeping the said recommendation as valid and operative. In a writ petition, this writ petition is disposed of with a direction to the Commissioner and Secretary to the Government of Assam Revenue Department to take the cases of the petitioners on record and pass final order in the matter of claim of the petitioners for settlement of the land in question, keeping in view the present policy of the state government. In the matter related to settlement of land, it's a continuous sentence, state government in the matter relating to settlement of land. The authority concerned will pass an appropriate order as indicated above, as expeditiously as possible, in any case within a period of 6 months from the date of production of certified copy of this order. Needless to say that any such view that the authority may like to take in the matter will be supported by adequate reasons in writing, and if such authority considers it necessary to give the petitioners an opportunity of hearing to arrive at a just decision in the matter, it will be open for the authority to give such reasonable opportunity to the petitioners. This till finalization of the claim of the petitioners as directed by the order, if the petitioners are in possession of the land as on today, such possession shall not be disturbed. With the above directions, the petition is disposed of. So, here, by this order of this honorable court, the initial recommendation of the board, Land Advisory Board, was made operative and said that the cancellation was illegal and this should be treated as a valid order.
That was a recommendation.
That was a recommendation of the board.
Finalization is by the government, is to be by the government.
Fine. On the basis of that recommendation, government was directed to pass a final order, reasonable order, fair order, if necessary, hearing the party. This order was not complied with for long. And thereafter, what happened? Next page, Lordship will see. The Authority, the deputy commissioner wrote to the subdivisional officer, submission of settlement proposal in the name of Ismail Ali. That was the subject matter. Petition. That is the petition. High Court order dated so and so, 1433-56. Ismail Ali versus, which refers to the above subject. I am to inform you kindly to submit settlement proposal in the name of Ismail Ali with all necessary documents for disposal of High Court order. It appears that Ismail Ali get 7 bigha 1 kata 17 lessers land under MNP, minimum need program scheme in Paschim
89 police.
Colony, some dag number so and so under normative Moza, and he also get rupees
1989
2,500
policy.
as aid for construction of the house under MNP scheme. So he was asked to submit proposal. It was mentioned that under MNP, he was given help to construct house and he is possessing that land. Then this was again on 21/10/2003. No?
21/10/2003
21/3.
subdivision.
It is to the subdivisional officer by the additional deputy commissioner.
So that
It says, my lord, subject submission of settlement proposal in the name of Ismail Ali, High Court order, reference is given. With reference to the above, I am to inform you kindly to submit settlement proposal in the name of Ismail Ali, which necessary documents, if the expiring, if the existing file is lost, the same may be reconstructed for admission, for submission to the government for consideration of settlement. This was, my lord, this reply of the subdivision officer was not there, but then they informed that the file is missing, therefore he was asked to reconstruct the file even while submitting proposal. So this was remained in that stage lying for long, and therefore again they had to come before this honorable court by filing another writ petition at page 47, annexure 9. This writ petition was filed and disposed of on 25/4/2013. Writ petition was filed in 2005 and it was finally disposed of on 25/4/2013. At page 47, my lord, I am reading it. At Mr. So and so. By means of this writ petition, the petitioners numbering 6 have prayed for a direction to the respondents to pass necessary order for settlement of land measuring 7 bigha 1 kata 17 liters in village Paschim Jaroni, Mauja, Naumati, district Nagaon, covered by Dag number 120 and 121 in terms of resolution and order dated 26/9/94 and 12/1/96 passed by the Land Advisory Board Hosai and the judgment dated 18/7/2001 passed by this court in CR number 1433 of 96. By order dated 18/7/2001 passed in CR number so and so with the following directions. Then the entire direction has been quoted here. We may skip this now, Manu.
Yes.
Now, in the next page, Mala,
Yes.
third para. after paragraph 5. First paragraph 5, then come to second paragraph. In the counter affidavit, paragraph 5, first paragraph
Yes.
concludes the quoted judgment. In the counter affidavit filed by the respondent, in that case, in this particular case, it has been stated that the land in question is reserved as pond and the banks of the pond as per land records, and there is serious dispute between the petitioners and the people of the village in respect of the land. It has been stated that as per the usual practice, the ponds reserved is in government land are meant for drinking source of cattle and cannot be settled against any individual person. In paragraph 12 of the counter affidavit, it has been stated that the petitioners and their family are not landless persons, as they possess 40 bigha, 3 katha, 17.5, 1/4 lessons of PP land under Doboka Revenue Circle. For a ready reference, the said paragraph is quoted below. 12 has been quoted that with regard to the settlement statement made in paragraph 13 of the writ petition, it may be stated that the answering deponent did not fail to comply with the direction in the judgment dated 18/7/2001, passed by the Honorable Court in C.S. so. The above judgment directed the respondents to settle claim of the petitioners for settlement of the land in question, keeping in view the present policy of the state government. The present land policy of the state government 1989 spells out that government land can be settled only against landless persons, and no pond reserved in government land can be settled against any individual. The answering respondent did not sit over the matter as a thorough inquiry was made regarding the eligibility of the petitioners regarding settlement of the land in question, which took some time. Accordingly, it was revealed that the petitioners and their family are not landless person, as they possess 40 bigha, 3 katha, 17 and 1/4 lessons of PP land under Doboka Revenue Circle. Moreover, it was also revealed that the land in question is recorded as pond and its banks as per office records. The above such facts disqualifies the claim of the petitioners for settlement of land in question as per Gov Land Policy 1989. This is quoted. The only requirement, now the court's finding. The only requirement for the respondent was to pass appropriate order. In terms of the judgment and order dated 18/7/2001, passed in C.R. Swens, the manner and method in which the order was to be passed was indicated in paragraph 4 and 5 of the said judgment and order, which has been quoted above. In view of the above, the writ petition is disposed of directing the government of Assam in the revenue department to pass appropriate order in terms of the said direction as expeditiously as possible. Let a copy of this order be furnished to Mr. Sojo, Planet Council for the state. Now, to my understanding, this order of the Honorable Court by Honorable Justice Soma, dated 25/4/2013, referred to the earlier judgment of the this court, dated 18/7/2001, and the observations and directions given in paragraph 4 and 5, and then recorded the facts Now they have revealed, the respondents revealed in this petition. This fact was reproduced as such. And have directed that now you pass an order. This honorable court in this order held nothing. Simply said that you pass an appropriate order. This was the direction 4-5. Follow this and
Yes.
pass an order. The order dated 4-1, 18/7/2001 was only reiterated. That being the position, the authority has now passed an order. At page 50, yes. Annexer
10.
Annexer 10, madam. Things are very not properly placed in my copy. Or you need the kind of point of it. This is the order now coming on 29th of September 2014. My Lordship has noted the duration which has been taken by them, the gap between one order and the other order, and the process how they went in. Where is the petition? So and so. Now, Ismail Ali, these are the 6 persons there. Sons of Muhammad Abdul Aziz, they are all brothers. They are all brothers. And village so and so, Daboka praying for settlement of land in Dag number 170, 171, Poshim Jaroni. The same decimation has been given under normative measures pursuant to the order of the Honorable Court dated 25/4/2013, passed in WPC number so and so. In fact, this order, this Honorable Court has directed to follow the alia order. They have referred to this only. Where is the order of this Honorable Court, High Court on 25/4/13, passed in WPC number so and so, wherein it was provided that appropriate order in terms of the judgment and order dated 15/7/2001, passed in CR number so and so, be passed. Yes. Also peruse the order of the Honorable Gauhati High Court passed in civil rule number so and so 96, 18/9/7/2001. The said order issued a direction to the Commissioner and Secretary Revenue to take the case of the petitioners on record and pass final order in the matter of claim of the petitioner for settlement of the land, keeping in view the present policy of the state government in the matter relating to settlement of land. It was also provided that the authority, Commissioner and Secretary, may give the petitioners an opportunity of hearing to arrive at a just decision in the matter. The petitioners were heard in person on 30/8/2014. Muhammad Lutfur Rahman represented the other petitioners. The SDO Civil Hojai or his deputy could not attend the hearing since the officers had to be busy with works of by-election of Jamna Mukhalis. The contention of the petitioners was that they were occupying the lands under Dag number 120 and 121 in village so and so, Moja so and so, over last 40-50 years. Though land in question is a pond and a bank of the pond, the same has not been used by the public for the locality. Besides, they do not possess any patta land, as reported by revenue officials, and they are landless. There was a need to hear the SDO Civil Hojai or his deputed officer along with relevant land records, and the next date was fixed on 23/9/2014. On 23/9/2014, Circle Officer Doboka was present along with relevant land records. The petitioners were absent due to perhaps a bond called by some organization. The Circle Officer Doboka was heard. He submitted a report furnished by SDO Civil Hojai. Peruse the report of SDO Civil Hojai. It transpired from the report that the petitioners possesses land property as indicated below. They have given this chart, this Moja, village, patta number, Dag number, area. those are, they have given, then Lordship will see. The circle officer reported that the petitioners have been occupying the land in question by cultivating vegetables on the bank of the pond. The circle officer Doboka furnished a copy of the minutes of the Subdivisional Land Advisory Committee, Hosai, held on 12/11/96, whereby the proposal of settlement of land in Dag number 120, area 3 bigha 3 kata 5 lasas, and Dag number 121, area 3 bigha 3 kata 12 lasas, which Muhammad Ismail Ali was rejected, recording the reason that there was a high court case, there was public objection, there is patta land, and the land is reserved as pond. The copy of land records, namely trace map and sitha produced by the circle officer Doboka, have been examined. In the remarks column of sitha against Dag number 120, Pukuri Par, bank of pond, while against Dag number 121, Pukuri, pond, have been found to be recorded. The circle officer Doboka maintained that the pond has been utilized by villagers of the village and public utility of the pond would always be there. Having on record all the materials, evidences, and other submissions of the petitioners as well as that of the circle officer Doboka, it is considered that the petitioners do have patta land and they are not landless. Besides, the land encroached by the petitioners is being used by the public, and the land by very nature of it would be public utility in future. The Subdivisional Land Advisory Committee, Huzai, also rejected the proposal of settlement. If it is therefore decided that there is no ground for giving settlement of land of Dag number 120 and 121 of Pasim Jammu so-and-so under so-and-so to the petitioners. The petitioners be evicted from the land in question forthwith for retaining the land for public utility. I am against this order. My lord, firstly, my full submission would be, in view of the order earlier passed in that petition, whether these grounds are now available for the respondents to raise. Because the issue relates to 93, 94, 95, that period. That period. The judgment and order passed in CR number 1433 of 1996, 15/7/2001. This has crystallized the rights of the petitioners. Every consideration now, although made in the year 2014, must relate to that period.
How the rights are crystallized?
Sorry?
How the rights are crystallized?
Rights are crystallized by holding that the recommendation that was made in my favor is valid, a cancellation is bad, and that is operative now. Whether those recommendations were at that point of time was irrelevant.
What is the stand about this that you possess lands?
That is, my lord, of late now, I got some land by way of inheritance
Inheritance from
from my grandfather.
Abdul Aziz.
Yes.
Abdul Aziz.
Abdul Aziz or his grandfather, I am told. He has inherited some land. Now,
He or they?
all brothers.
All brothers of one father, Abdul Aziz.
Yes.
And Abdul Aziz, when did he expire?
Abdul Aziz कितने टुकड़े से को पाइब ना टिकट लिखी दिया. Because all what was the objections taken by them in the first that writ petition?
Second repetition, second one.
No, Malad.
In the counter affidavit they have filed. In the earlier one, it was not filed.
No,
In the first one,
my
at
instruction
page
is
38,
yes,
so it is there. The court has recorded that fact.
yes, because all those documents are there.
Because it has been said
Yes.
that page 40, treating the said recommendation as valid and operative,
Yes.
the direction was to dispose of the claim of the petitioner.
Exactly. So,
And last observation, paragraph 5, till finalization of the claim of the petitioner as directed by this order.
yes,
So finalization of the claim for settlement.
settled.
And it was set aside because no adequate reason
Was given.
given and no right reasonable opportunity of being heard was accorded to the petitioners.
Yes.
These are the two grounds.
Yes.
Other grounds that is not there.
No, other grounds the court has.
That is your claim that the right has been crystallized.
My lord, my right to be considered on
Right to be considered for
Considered-
settlement.
settlement on the basis of the recommendations made in that
This is an advisory body.
advisory body. What
It
were
is
the
not
facts?
a, not
Because
a,
that
not,
time,
not
now-
a, whose
now why-
recommendation may not be binding on the
Yes,
settling
exactly.
authority.
exactly, exactly.
I have seen clause 19.1
Yes, exactly.
of the land policy.
Land policy. Binding, it is not binding, but this gives a
It is advisory body.
advisory body.
It is clear.
So accordingly, the authority has to consider.
Ah.
If to reject,
Taking
they also
into
take it.
consideration the recommendation of the
Yes.
land advisory committee.
Yes, and they retain the right either to grant or not to grant.
Ah.
But they will have to cite reason for that. That's why this honorable court has said. that-
All are sons of Abdul Aziz.
Abdul Aziz.
And Abdul Aziz, from Abdul Aziz, they have inherited their lands, some lands,
Yes, of late.
of late.
Yes.
And
That
at that time, when you preferred the first repetition or second repetition, Abdul Aziz was alive or Abdul Aziz was?
He was alive that time.
He was alive.
He was alive.
Yes,
He was alive.
he was alive.
Yes. And
So you petitioners were in possession of that plot of land.
that plot of land, we were all in possession. There is an admitted case that we are in possession there. And now they
You
want
took
to.
in possession,
Yes, we are in possession.
but
So-
that fact is somewhat disputed in the counter affidavit.
That is, well, that
Somewhat disputed.
is somewhat
I'm
disputed. Well, in my full submission.
What is your answer to their claim that you have inherited this?
Well, that is admitted. Now, of late I have inherited it.
Hmm.
That certain portion, I have got some land now by way of inheritance. Now, after a distance of so many years, I have inherited some land. But whether by that itself, my right to be considered on the basis of the policy and the authorities grant made to me under MNP, that was given to me to even construct houses there. And therefore, this is admitted. Deputy Commissioner asked for proposals, that you give proposals and indicated that he was granted under MNP to construct houses thereon. This amount was given to him. So you submit proposal. But thereafter it didn't come forward. Ultimately, when we approached this honorable court again, they came up with certain new facts. That is my response. Whether all these new facts, because at that time, whether it was a pond, whether on record, it was a pond there, no, nothing. All these have been brought in leather.
You have to dispute it then.
My lord.
It is pond is pond.
If
In a cheetah, they have produced a cheetah.
No, Sita is.
They have produced a cheetah.
My lord, Sita is.
Pond means pond.
My lord, whether, my question is, whether that was recorded in the earlier also in the Sita, when the authority considered it, Land Advisory Board considered it, This point was never raised before.
By the subsequent order, after taking note of the stand of the state respondents, by the subsequent order dated 25/4/2013,
Right,
page 49,
yes,
last two paragraph,
no,
the court has made it clear.
yes. They are to pass an order.
4 and 5 paragraph are to be noted.
Then their submission has been recorded.
Yes, and thereafter, the only requirement for the respondents was to pass appropriate order in terms of judgment so and so. The manner and method in which the order was to be passed was indicated in paragraph 4 and 5 of the said judgment.
Said judgment.
And petition is disposed of directing so and so as expeditiously as possible.
Right. So, Malak, as I have submitted already, this order of this honorable court dated 25/4/2013 said nothing except directing that you act under 4 and 5
And the land
Paragraph-
policy.
and pass an order.
And the land policy.
And the land. That was mentioned in earlier order also, 4 and 5.
Earlier, all
Yes.
are as regards the land policy.
Yes, land policy, because land policy would be definitely considered and my entitlement will come under that. Now, my question is, Malat, they are rejecting my case on some ground which have been subsequently cultivated by them.
No, it is not a cultivated thing. They have produced the facts.
Malat,
They have produced the facts. It is not cultivation.
No,
It is not a way of cultivation. Abdul Aziz was in existence.
Malat,
And after his death, these petitioners have inherited the land. They have produced the facts.
that I have not disputed.
Right.
But the question is that it was a pond that was reserved for, and the public have raised objection. Those were not there.
Public have raised objection. There is a different matter.
Yes, nothing.
But let us,
It was not in
let us see the Sita copy.
It was not in public.
Let us see the Sita copy if they have produced it.
Here.
This is of 1968, 69, Mr. Mohanto.
My lord.
This one. This one.
Yes, Sita.
Please see here.
Yes, my lord, I have this.
Ah. '68, '69.
121, 120, 20.
And you claim occupation since which period?
Since 75. 75.
75. Land and Revenue Regulations.
It is 68, 69. Had it been there, probably, had it been there, the authority.
These are by 114. Evidence, these are to be presumed to be correct, unless you rebut it.
Well, that is why my response submission is, these records are updated over a period of 10 years or 12 years.
This,
These records are updated. That is why my question is, whether those were placed before this honorable court at the first hearing of that petition in 2001. Therefore, I filed an application that for calling for those records, because the entire relevant records are attached.
by your inheritance by the subsequent date, whether you
I'll be
still have the right to claim possession of government land, settlement of government land. Because subsequent events, even if we treat this as subsequent events,
Yes,
and considering the nature of the land
yes,
which were in occupation, pond and bank of the pond,
yes,
Rule 18.2 of the settlement rules,
yes.
these are for public purposes. Pond is government land, pond, bank of the pond, these are 18.2, Rule 18.2.
82.
Nobody can claim other than VGR, PGR, there are other lands which where one cannot claim possession.
If the land is reserved.
And same policy says page 22, who is Ismail Samsul Haq, one of the petitioners?
Samsul Haq. My petitioner hasn't.
Petition number 6.
Yes.
He paid Tozi.
They paid Tozi, yeah.
Tozi is
Tozi is only a fine.
Bedokoli Jorimona.
Yeah. It cannot.
From Radha Kanu,
Yes, yes, sir.
it is Bedokoli.
Yes.
Meaning thereby, then land policy says an encroacher remains an encroacher
Yes.
always
Yes.
until it is settled in his
Yes.
favor.
Yes. Therefore, my question is, Lordship has raised a pertinent question. Whether my inheritance, subsequent inheritance of some land will disqualify me to get the land, to consider my case for settlement before 30 years or 40 years. After 30, 40 years, I have acquired some land. Obviously, it is not the policy that one landless will always remain a landless. I got some land by way of inheritance. The distance of 30, 40 years.
And incidentally, all 6 are sons of
the
Abdul Aziz.
Abdullah.
And it is after the death of Abdul Aziz,
We have inherited. Yes. That time, no.
you have inherited. As at that point of time, Abdul Aziz was surviving. So it was not inherited, but you were successors in interest.
Later on.
And it is not that there's 1 bigha of land.
But they say 40
How much? How much?
They say.
Total?
Some 40 bigha or 70
40
bigha.
bighas.
I am not on that quantum.
Lands are scarce.
True.
Public interest demands that it should be distributed to landless.
Yes.
At that point of time, you were landless because Abdul Aziz was surviving.
Survive. So my consideration relates to that point. Therefore, my question is, my subsequent inheritance will not disqualify me to get my case considered at the relevant point, some 30, 40 years prior to the inheritance. Had it been considered, if I ask the question to myself, supposing my case was considered at that time favorably and I was settled with the land. Now, subsequently, when the authority found that I have inherited some land, whether that settlement, earlier settlement would be satisfied or land will be taken back? Obviously not. Obviously not. The authority did not consider that time, although recommendations were there. That is why this honorable court said that you now consider and pass an order. Whether at that time the authority raised these questions that no, the land is a reserved land, it is a reserved, shown as a reserved land in the Sita, that it is a pond and we are occupying the pond as well as the bank of the pond, it is for public utility. All those facts were never raised by them. Therefore, we have filed an application, but those documents are not with us now. Those are a part of that writ petition. Therefore, we have filed an application, this is before your lordship also, IA, to get the records of those cases. Lordship can verify whether those were raised at that point of time or not. If those were raised, I am out. If they have not raised those points at point of time, now after 30 years, if they come in and say, produce some records that no, it is a reserved land, in my respectful submission, that will not hold water for them. Because these land records are updated every after 10, 15, 12 years. And here, Lordship will kindly mark one more aspect. The fight was the respondent number 4, he was the local level of that period. At his instance, this he was sought to be evicted. Our categorical case was there. He was respondent number 4 here.
Who is respondent number 4?
He is, my lord, some rugby. What is his name?
In my brief, it is not there.
No, you cannot know.
No respondent number 4 in my brief. Perhaps.
Yes. Yes, rugby to rugby. Well, that page 37, Lordship will find. This was there.
No, in the present petition, he is not there.
No, it is not there. Earlier it was there. Because
First order of 2001, thereafter 2013, we have to read these two orders.
yes, yes.
Yes, Mr. Talukdar.
So, Malab, before that, I may just place certain provisions of law, how to consider it. Because my case was also in the earlier it was on 96, then later on this Abdul Jalil Rugby, he was the MLA that time. He was
No, he is not a party here and nothing has been discussed in neither of the two orders.
not
Neither of the two orders. These are extraneous now.
no facts was
Neither of the
recorded
two
there.
orders.
No, facts was recorded that it was against response number at the instance of response number 4. That was of course mentioned. No finding has been erected. No finding has been. Only reference was made that at his instance this was done. Well, so Lordship will decide, madam.
Yeah.
I will just make a submission
Yes.
to my understanding what should be, and rest will follow from your Lordship. Kindly see, madam. Yeah, firstly, legal question, that if I have inherited some land at a later point of time, that will not disqualify me from being considered or from being allotted or granted some land if I was landless at that point of time, as per the recommendation of the board, that committee. And then when this application is filed, then it is the duty of the authorities to consider how. That your Lordship will see. If I take your Lordship to that land and revenue regulation rules,
Yes.
Lordship is there.
Yes, it is there.
If this book, my lord, then I will invite your Lordship to page 203.
Green conduit.
Assam Law House, my lord, this.
Volume
One.
1.
Volume
Page.
page 203.
Yes.
Now, my lord, definition part, Lordship will see wasteland.
Hmm.
Wasteland means land at the disposal of the government, which the government has not disposed of by lease, grant, or otherwise, and which is not included in a forest reserve or in a forest proposed to be reserved under Section 5 of the Assam Forest Regulation of 1891, or in a protected forest constituted under the rules made under the said regulation, and has not been allotted as a grazing ground under rules framed under Section 13 of the Assam Land and Revenue Regulation. Therefore, my lord, when it is open, a wasteland, then it is open for settlement. My respectful assumption is that at the relevant point of time, when the recommendations were made in my favor, the land was a wasteland. It was neither reserved for any purpose, nor it was a forest land, nor it was shown as a public utility, hence a natural pond. Those facts were not there. Therefore, subsequently bringing in those facts will definitely cast a doubt, and this will not disqualify me from being settled. Then Lordship will kindly see what is settlement. Next page 204. F. Settlement in these rules means the leasing of land at the disposal of the government and includes the operations of survey, classification, and report preliminary to the such leasing. Therefore, when an application is made, they have to follow this procedure. Include the operations of survey, classification, and report preliminary to such leasing. Whether they obtained this report, it was at the earlier stage itself. Therefore, the advisory board recommended my case. Then Lordship will kindly come to next page 206. The power vests with the Deputy Commissioner. Rule 2. The disposal of waste land required for ordinary or special cultivation or for building purposes will vest in the Deputy Commissioner, who will dispose of such land by grant, lease, or otherwise in the manner and subject to the conditions set forth in the rules following, provided that the Deputy Commissioner may expressly reserve any such land from settlement, provided that no land in any unclassed state forest containing trees declared as reserve trees under Section 32 of the Assam Forest Regulation 1891 shall be settled, except with the previous approval of the state government. Then this power can be delegated also. Next, Rule 3. Deputy Commissioner may by general or special order delegate to any revenue officer within the district all or any of the powers conferred by these rules, including the power to receive applications for land provided that no officer of lower status than a sub-deputy collector shall pass final orders to issue a periodic lease or to grant settlement of land, and provided that such deputy collector may not exercise such powers if the land in question exceeds 12 bighas or such other areas as may be prescribed by the state government by general or special order from time to time. If it is beyond 12 bighas, of course, Deputy Commissioner doesn't have. We were within that limit, 7 bighas and something else. Then Lordship may skip. Rule 5. Application for land. Application for leases of waste land shall be in writing and shall be presented to the Deputy Commissioner or to such other officer as may be empowered by the Deputy Commissioner under Rule 3. They shall be made in such form as the state government may from time to time direct. Now, measures and classification of land 6. On receipt of an application for land not exceeding 50 bighas in area, the Deputy Commissioner or other officer empowered in this behalf shall, in surveyed areas, unless he sees reasons to reject the application, summarily cause the land applied for to be shown on the cadastral map. In unsurveyed areas, maps shall be prepared in such cases or class of cases as the Deputy Commissioner may by grant or special order direct. The land records staff shall at the same time report briefly whether the applicant is a person belonging to any of the categories mentioned in Rule 8 and whether the land is available for settlement and suitable for the purpose mentioned in the application, and what rates and revenue are applicable to the land under general or special orders of the state government, or if no such orders apply to the land in question, what rates of revenue will be suitable having regard to the rates prevailing in the neighborhood for land of the same class. So this exercise was carried out in my case earlier, my lord. Appeals against wrong measurements, classification.
What is the basis of your right?
My lord, my right
To claim settlement?
to claim settlement, my right is that time I was a landless person and I paid for, and I have a right to be considered by following the due process.
For this particular plot of land,
For the particular.
what is the right?
For the right, my lord, as I said.
Right to claim settlement of this particular 7 bighas something.
My right emanates from the rules only. When there is a wasteland, one can pray for.
Yes, like you, anybody can.
I can pray.
Why you should be preferentially treated?
No, but I have not asked for preferential treatment. I asked for, as usual,
settlement.
As a landless person, I should be granted.
Because that is because of your long occupation.
Wrong occupation, or Lordship may say, I came into occupation by virtue of an order where MNP, minimum need program, I was given to construct houses there over that law. Therefore, I am permissive occupier. I will treat myself as a permissive occupier, not as an encroacher at the initial stage. Deputy Commissioner has mentioned it. Lordship has seen it.
Which part? Where it is mentioned
Uh,
that
that
permissive occupier part.
that proposal was asked for, at page, yes. Page, my lord, 45. Second, only two paragraphs, small paragraphs. Once again, let
Page
us.
45.
Page 45. It was addressed to the sub-divisional officer by the additional deputy commissioner. With reference to the above subject, I am to inform you to kindly to submit settlement proposal in the name of so and so with all necessary documents for disposal of High Court's order. It appears that Ismail Ali get 7 bigha 1 katha 17 lessons land under MNP scheme. That is my. They got this MNP scheme in Pasim Zaroni Kisam Dag number 121.
Where is the relevant document regarding that?
That documents not here. Those are if those are submitted in the earlier.
Opposing consider.
He has indicated, and
Translation.
he also get rupees 2,500 as aid for construction of house under MNP scheme. So this deputy commissioner definitely he has consulted on record. He has given this report on record. Therefore, my response submission is there. I have a right to be considered fairly. I have a right to be considered fairly, and that time they never raised any such plea that this land is reserved land. In fact, or that this was a public utility, there was a pond, nothing. Nothing. It was not that. During rainy season, some low-lying lands are always there, some water accumulates. That cannot be termed as a pond. But that is a subsequent development they have brought in. Brought in. They have, initial stage, they have surveyed under Rule 7, surveyed the land. Then they have to consider under Rule 8, this how to dispose of the application.
Yes.
So, my lord, my respectful submission. The being a landless, he is entitled to be considered under Rule 8.
Yes.
My lord, Rule 8 for the time being, my lord. After perusing the report and the map and making such further investigations as may seem necessary and setting and settling any dispute that may have arisen, the deputy commissioner or other officer empowered in this behalf shall either reject the application or grant a lease or allow it in part. This is also there. They may not grant me the entire, my claim as a whole. They can grant some. Priority of applications, then kindly see. The granting lease, the deputy commissioner shall take the following into consideration. Settlement for agricultural purpose of lands available in compact block of 50 acres or more will be made ordinarily with registered cooperative society. We can skip. When settlement has to be given to individuals, the area should ordinarily be limited to 8 bighas to 12 bighas per family, according to the fertility of the soil. In giving settlement to individuals, preference shall be given to the following order. Settlement holder who have been rendered landless due to flood, erosion, or earthquake, or due to requisition or acquisition of their land by government for public purposes. B. Landless cultivators and displaced persons from Pakistan who were landless cultivators. So, I come under B. C. Cultivators having less than 8 bighas of land. So, I come under C also. Cultivators having less than 8 bighas of land. Therefore, my response submission is entire procedure was followed or not at the initial stage when the recommendations by the board was given in our favor. If that was so, then those are the foundational facts. Those are the foundational facts on which the authority will have to pass an order. Even today, they cannot bring in new facts. Therefore, the impugned order, which is passed on the basis of some recent facts, cannot be held to be just and reasonable. Therefore, the order cannot sustain. It has to go back to the authorities to take into account and duly comply with the order of 2001 petition, Honorable Justice Gogoi, and pass an appropriate order, keeping in mind that direction. At that point of time relevant, not subsequent. If those facts appear also in those papers, then of course they can always take into account and pass an order. But what I mean to say is, in the subsequent writ petition, they came up with some new facts. That has been recorded by the court that this is their now statement. But you pass an order referring to 4 and 5. So it has said nothing. No, it has the subsequent judgment of Honorable Justice B.K. Sharma has not held anything else. No finding. Only simple direction that you pass an order. You have said all this, but you pass an order.
And 4 and 5.
4 and 5, yes. And my response submission is to my
4 and 5 also says nothing.
But it says,
That treating the recommendation of the as valid and operative. That is
Yes.
advisory recommendation of the Land Advisory Committee. It is disposed of and it has been directed to the Commissioner and Secretary,
Yeah.
Revenue,
Yeah.
to take the case of the petitioner on record and to pass final order in the matter of claim of the petitioner for settlement of land in question, keeping in view the present policy.
Right. That time.
Right.
Yes.
That is 1989 policy.
Yes.
Then
89
5,
policy.
needless to say, any view that the authority may like to take in the matter will be supported by adequate reasons in writing.
Yes.
And plus, an opportunity of being heard
Yes.
is to be afforded.
Yeah.
And till finalization of the claim,
Yeah.
petitioners, if they are in position, they should remain in position. That's all.
So we are
I think
clear.
no finding has been recorded
No, only
by the
finding-
court. Only finding is that let us treat the recommendation of the Land Advisory Committee as
Exactly.
valid and operative
Exactly.
and proceed from that stage
Exactly.
onwards.
Exactly.
That is the
my-
only ground.
That's my submission.
That's
That is the only.
Yes.
So on that foundation, they must proceed. Foundational facts are on that basis. They cannot bring in any subsequent facts. Those facts brought in and recorded by Honorable Justice Soma, those facts only they have stated facts, but those have no bearing at all.
Yes.
That is my full submission for you. Because otherwise, having taken into consideration all these background facts, in letter and spirit, complying with the directions in paragraph 4 and 5 of that judgment, if they take the call, then of course they will decide whether I have a right or not. Whether I come within those parameters as prescribed under Rule 8 or not. But they cannot raise that subsequently I have acquired some land by way of inheritance. That cannot be a ground to deny me. That is my limited case, Malu.
I'll resume after 5 minutes.
On the facts now available on the basis of the judgments 2001 and subsequent decision, the new facts cannot be brought in, and what I have submitted before your lordship will have to take into account and decide. And if your lordship feels like that further some revelation is necessary for a fair decision, my application is pending before your lordship, i.e. the records of that particular case may be brought in. What was the plea they have raised at that time? Lordship's satisfaction, that can also be seen there in their affidavit filed. The affidavit filed in 1433 of 1996. And what was that resolution? Whether a resolution mentioned about the nature of the land, nature and character of the land, that can also be taken care of if these are part of that earlier resolution, 96, 1433 of 1996. Those are not with us, but those documents form part of that resolution. Therefore, those are relevant. And if the record is called for, those will appear.
Let us hear Mr. Talukdar.
Yes.
My lord, my first submission is, my lord, they cannot have any right over that particular plot of land. It's under the government policy. If they're landless, under the government policy, they can apply. They can be given settlement to any plot of land, government cast land. Or it can be rejected also. Now, the 2013 judgment doesn't say anything. It only refers back to 2001. Last part of the 13 judgment, my lord. In view of the above, the writ petition is disposed of directing the government of Assam in the revenue department to pass appropriate order in terms of the said direction. My lord, so it goes back to paragraph 4 and 5 of the 2001 judgment. So 2001 judgment, paragraph 4 only says the government of Assam Revenue Department to take the case of the petitioners on record and pass final orders in the matter of claim of the petitioner for settlement of the land in question, keeping in view the present policy of the state government in the matter relating to settlement of land. So, while considering their case, my lord, the government has to take into consideration of the present government law policy, land policy, I'm sorry. And paragraph 5, needless to say, any such view of that the authority may like to take the matter will be supported by adequate reasons in writing, and if such authority considers it necessary to give the petitioner an opportunity of hearing to arrive at just a decision in the matter, it will be open for the authority to give such reasonable opportunity to the petitioner till finalization of the claim of the petitioner as directed by this order. If the petitioner is in possession of the land as on today, such possession shall not be disturbed. So, admittedly, that was not done, my lord, till at least 2013, when the second order was passed. So, petitioner was also sitting over the matter. He did not go anywhere, or he did not come up with any contempt petition. So, second writ petition comes up, and the Honorable Court says that you just passed an order as directed in the 2001 writ petition. There were two issues raised by the respondents. Firstly, they are not landless. That is, of course, a subsequent issue. But the land has always been a pond or nearby areas of the pond. It could not have been settled today at any point of time. Even my lord, going back in time also, under the earlier land policy, it could not have been settled with them. So his argument fails that that particular land cannot be given to him. And he will have no right over that particular plot of land, even for long possession, long or wrong possession. It is a wrong possession, my lord. They are encroacher only. And they are paying Toji Mahira, that is Bedakhali Jorimana. Therefore, the revenue government has rightly passed the order. Even if the second issue fails, my lord, but the first issue is there.
First issue?
the pawn cannot be settled to anybody. And there is a finding somewhere that it has been used by the public. Hmm? Hmm? Hmm. 50? Page 51, may I take a lordship to page 51. The circle officer reported that the petitioners have been occupying land in question, cultivating vegetables on the bank of the pond. The circle officer Doboka furnished a copy of the minutes of the subdivision land advisory committee held on so 96, whereby the proposal of settlement of land in Dag number 120-121 with Muhammad Ismail Ali was rejected, recording the reason that there was High Court case and there was public objection. There was patta land. Land is reserved as pond. The copy of the land records, trace map, and chita produced by the circle officer have been examined. In the remarks column of the chita in Dag number 120 is Pukuri Par, Bank of Pond, while against the Dag number 121 is Pukuri, have been found to be recorded. The circle officer Doboka maintained that the pond has been utilized by the villagers of the village and public utility of the pond would always be there. So, if we do it retrospectively also, we cannot settle that particular land to the petitioner. That is not landless. Uses that for the finding method. It কিন্তু তাতে ফাইন্ডিং নাই কত
Yes, anything?
Well, that is my, so, but affidavit has been filed by the department, my lord. It's only two issues are taken in the affidavit, land, they are not landless and secondly, the pond. If the first issue goes also, second,
What do, according to first issue?
it says in the affidavit filed by the department, the first issue is they are not landless. So in terms of the policy, they cannot be settled with government land. Second, it says that the land which they are occupying is a pond and the nearby areas. So it cannot be settled. There is specific bar. That comes from their affidavit, my lord, the revenue department. And it is not a government policy that you forcefully occupy some land and apply and you acquire any right over that particular plot of land.
Yes, anything in response?
Yes, my lord. Only thing I would like to just say, because I have already made my submission. Here, Lordship will see, they have committed the error while pursuing the impugn order, one more glaring error. The authority referred to the cancellation order at page my learned friend has referred to page 51. 51. After the table, the circle officer reported that the petitioners have been occupying the land in question by cultivating vegetables on the bank of the pond. The circle officer Doboka furnished a copy of the minutes of the subdivisional land advisory committee held on 17/11/96, whereby the proposal of settlement of land in Dag number so and so area so and so with Muhammad Ismail Ali was rejected, recording the reasons that the High Court case there was.
That would not have any value because of the 2001 judgment.
Yes,
That I know.
that's only I want to point out.
That is
You
correct.
have to have taken the
That is correct.
recommendation only.
Para 4, first line.
Yeah.
You have to take the application forward from the stage of the recommendation of the land advisory committee.
Taking it to be valid.
Yes.
Taking it to be valid.
As
That is only recommendation, also. The final cause.
No, whatever may be. That
12/11/1996, that the 2001 judgment has taken care of.
yes.
Yes.
So
That
they
I-
relied upon that and said that these are the reasons, therefore rejected. We are acting upon this. This they cannot do. That is the glaring error. They should have considered the recommendation order, the grounds given there. If those are non-subsisting that time, then of course they can take the call. But which High Court has set aside this and taken that this original order suffices. That is the glaring error in the impugn order. That cancellation order has influenced the mind of the authority. They have not considered that document annexure 8, which was mentioned there. (12/1/96), there was a recommendation. Annexure 8. That was not considered. That is the foundation. Well, 11/96 was already
Written.
12/11/96 was already set aside by this court.
Yes, sir, that is impliedly
That
done
lordship,
away with.
that lordship will take it off. But they relied on that and went ahead.
Just may I take leave for a moment, my lord?
We'll start and we'll resume at 2 o'clock again because.
Lordship will pass
The-
order, my lord. That
Yes.
we have completed our.
Yes. Now it is my part.
Yes.
Only for a moment, my lord. I'll be.
My juniors will be
Sure.
deeply obliged.
The instant writ petition under Article 226 of the Constitution of India is preferred by taking exception to an order dated 29/9/2024
Right.
passed by the Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management Department, page 50%, whereby the claim made by the petitioners for settlement of a parcel of land measuring, described here in below, measuring 7 bighas, 1 katha, 7 lesa, has been rejected. First, the petitioners have also sought for a direction in the nature of mandamus to the respondent authorities to restrain or forbear them from giving effect to the resolution passed by the Subdivisional Land Advisory Board, Hojai, whereby the allotment of land to the petitioners had been rejected. Full stop. Para. The parcel of land in respect to which the petitioners have claimed consideration for settlement is a parcel of land measuring 7 bighas, 1 katha, 17 lesas, located in village Paschim Jaroni, Mauja, Nomati, district Nagaon. Full stop. The parcel of land, hereinafter referred to as the subject land, subject plot, for ease of reference, comprises of an area measuring 3 bighas, 3 kathas, 5 lesas in Dag number 120 and 3 bighas, 3 kathas, 12 lesas in Dag number 121 of village, revenue village Jaroni, Paschim Jaruni, Jaruni, Mozanamoti, district Nagaon. First stop. Para. The petitioners are six in numbers, and they are 1, 2, 3, 4, 5, 6, and 6. Who are all sons of one Abdul Aziz, and all the petitioners are residents of village Paschim Jaruni, Maujanamoti district, Hojai, within bracket earlier, comma district Nagaon, bracket close Assam. Full stop. There were several rounds of litigations earlier. Para, full stop. The petitioners had earlier approached this court by way of 3 writ petitions, comma, civil rule number 3969, stroke 1991, comma, civil rule number 1433, stroke 1996, and WPC number 7692, 2025. Full stop. Para. It is the case of the petitioners that no, it is the case of the petitioner that they are in occupation of the subject land since more than 25 years at the time of institution of the writ petition. First of a part of the subject land were being used as the residence of the petitioner, and the remaining part were being used for the purpose of growing vegetable, etc. Full stop. It has been pleaded that long and continuous possession of the subject land since 1995 have ripened into title in respect of the subject plot in favor of the petitioners. Full stop. Para. The petitioner have stated, full stop, from the materials on record, comma, it has emerged that the petitioners submitted an application before the subdivisional collector Hojai on 11/1/1995. No. No.
1985.
1985. And SDC Hojai submitted a report recommending settlement of the subject plot in favor of the petitioner. submitted a report on 30/04/1985. Full stop. On the other hand, comma, the subdivisional officer, Hojai, has served an eviction notice dated 13/5/1985 upon the petitioners in connection with encroachment case number 14 of 1985. Full stop. Or for eviction of the petitioner from the subject plot. Full stop. An appeal preferred against the notice was dismissed by the Deputy Commissioner, Nagaon, the appeal preferred by the petitioners against the eviction notice and for settlement of the subject plot was dismissed by the Deputy Commissioner Hojai. Full stop. Thereafter, the petitioners preferred an appeal before the Assam Board of Revenue under Section 147, Assam Land and Revenue Regulation. Against the order dated 25/6/1985 of the Deputy Commissioner Hojai on 9/8/1985. Full stop. By an order dated 9/10/1985, the Assam Board of Revenue stayed an order dated 13/5/1985 passed by the SDO Hojai in encroachment case number 14/1985, which was a notice of eviction under Rule 18 within bracket 2 of the settlement rules framed under the Assam Land and Revenue Regulation 1886. Full stop. The petitioners had thereafter renewed their prayer, renewed their prayer, or the materials on record do not indicate what happened to the appeal, what finally happened to the appeal prepared by the petitioners before the Assam Board of Revenue. Posto. But it transfers that the petitioners had renewed their prayer for settlement of the subject plot in their favor before the respondent authorities. Posto. Para. In order dated 27/6/1995, passed in Civil Rule number 3969/1991, it was observed that the question of settlement of the subject land with the petitioners was being considered by the authority, and there was a resolution of the Land Advisory Board Hosai, Posto. By the said order, the civil rule was disposed of, granting liberty to the petitioners to file appropriate fresh application after the decision of the Assam Board of Revenue, Post of FERA. The subsequent litigation was in the form of civil rule number 1433/1996. Okay. At two. So, the application of the petitioner for settlement received consideration of the Subdivisional Land Advisory Board Hosai and in a meeting held on 12/1/1996, the Subdivisional Land Advisory Board Hosai recommended for settlement of the subject land in favor of the petitioners. Full stop. By subsequent resolution, dated 12/11/1996, comma, the land advisory board हो जाए, rejected the proposal for settlement of the subject land in favor of the petitioner. Full stop. In the in civil rule number 1433 1996, it was urged on behalf of the petitioners that the previous recommendation for settlement of the subject land was arbitrarily cancelled by the land advisory board हो जाए without notice to the petitioners. And without giving any opportunity of hearing to them. And on those grounds, comma, the subsequent resolution as regards rejection of the proposal was paid in law. Full stop. The court took note of the fact that the recommendation of the land advisory board हो जाए, recommendation dated 12/1/1996 of the land advisory board हो जाए, was not controverted by the state respondents by filing an affidavit. The court was of the view that if the case of the petitioners for settlement had been recommended, then such a recommendation would require consideration of the case, the petitioner's case for settlement. And the subsequent cancellation of the recommendation without notice would not have any bearing. Full stop. While disposing of the repetition by judgment and order dated 18/7/2001, comma, the court had observed that the recommendation of the land advisory board, comma, हो जाए, for settlement of the subject plot in favor of the petitioner, comma, taken on 12/1/1996 would have to be treated as valid, and a direction was made to the Commissioner and Secretary to the Government of Assam Revenue Department to take the case of the petitioners on record and to pass a final order in the matter of claim of the petitioners for settlement of the subject land, keeping in view the then land policy of the state government in the matter relating to settlement of land. Full stop. It was further observed that the decision to be taken by the authority should be supported by adequate reasons in writing. If such if such authority would consider it necessary to give the petitioners an opportunity of hearing to arrive at a just decision in the matter, then it would be open for the authority to give such reasonable opportunity to the petitioners. So it was further observed that till finalization the claim of the petitioners as directed by the said judgment and order, if the petitioners were in possession of the subject land, then such possession should not be disturbed. Full stop. Para. After the disposal of Civil Rule 1432 1996, the petitioners approached again in the year 2005 by way of another petition WPC number 7692/2005. Post of in the interregnum, there were correspondences between the subdivisional officer C. Ojai and the district commissioner of erstwhile Nongao district as regards submission of a proposal for settlement of the subject land in favor of the petitioners. Post of para. In the writ petition, WBC number 7692/2005, a counter affidavit on behalf of the state respondents was filed, taking in the alia a stance that the subject land was found reserved as pond and banks of the pond as per the land records, and there was serious dispute between the petitioners and the people of the village in respect of the subject land. And such reserve land, such government land, reserved for ponds, could not be settled against any individual person. Post of para. The repetition of WBC number 7692/2025 was preferred by the petitioners, seeking inter alia direction to the state respondents to pass necessary order for settlement of the subject plot measuring 7 bigha 1 katha 17 lessers in terms of the resolution dated 12/1/1996, passed by the Land Advisory Board, Hojai, and the judgment and order dated 18/7/2001, passed in Civil Rule number 1433, stroke 1986. Full stop. The court, taking note of the observations made in paragraph 4 and 5 of the judgment and order dated 18/7/2001, passed in Civil Rule number 1433, stroke 1986, and a stand taken by the state respondents in the counter affidavit. Disposed of the writ petition by an order dated 25/4/2013. Directing the state government in the revenue department to pass appropriate order in terms of the direction already made in civil rule number so and so as expeditiously as possible. The court had observed that the only requirement for the respondents was to pass appropriate order in terms of the judgment and order dated 18/7/2001, passed in civil rule number 1433, 1996. First up, the manner and method in which the order was to be passed. First up, Malaya, it already quote Koragas. Para. It was in the above backdrop of events, the impugn order dated 29/9/2014 came to be passed by the Commissioner Secretary to the Government of Assam Revenue and Disaster Management Department. Full stop. Para. I have heard Mr. K.K. Mohanto, learned senior counsel, assisted by Miss N. Begum, learned counsel for the petitioners, Miss Z. Hazarika, learned standing counsel, Revenue Department, for the respondent number 1, and Mr. B.J. Taluda, learned senior counsel, assisted by Mr. P.K. Medhi, learned junior government advocate, for the respondent number 2 and 3. Full stop. Para. Mr. Mohanto, senior counsel, appearing for the petitioners, has submitted that the grounds of rejection recorded in the impugn order dated 29/9/2014 to negate the claim of the petitioners are not tenable in as the claim a consideration as the consideration for the consideration of the claim of the petitioners for settlement are to be confined . to the directions made in the judgment and order dated 18/7/2001. He has contended that the recommendation of late Land Advisory Board, Hojai, recommendation dated 12/1/1996 of the Land Advisory Board, Hojai, has already been crystallized in favor of the petitioners. First up, any subsequent inheritance of any land in favor of the petitioner ought not to have been taken into consideration. First up, he has contended that at the time of submission of the application by for settlement, the land, no land, was in the name of the petitioners. Full stop. Being landless persons, the petitioners are entitled to be considered for settlement. Full stop. Such consideration for settlement is to be strictly in terms of the provisions of the Assam Land and Revenue Regulation 1886 and the then existing land policy. Full stop. He is further contended that new facts cannot be brought in subsequently to decide the application which was submitted much earlier to the institution of Civil Rule number 1433 1996 to support his submissions, Mr. Mohanty has referred to the definitions of quote-unquote settlement and Westland. Rule 2, Rule 5, and Rule 8. Of the settlement rules framed under the Assam Land and Revenue Regulation 1886. Full stop. He has further pointed out that the respondent number 1 while deciding the application was influenced by the recommendation dated 12/11/1986 made by the Land Advisory Board, Hojai, whereby the proposal of settlement of the subject land in favor of the petitioner was rejected. Yes, anything else? I missed out?
No.
Para. Ms. Hazarika and Mr. Taludar appearing for the respondents, state respondents, have extensively referred to the impugn order dated 29/9/2014 and the statements and affirmation made in the affidavit in opposition filed on behalf of the respondent number 1. Full stop. It is submitted that the case of the petitioner, the application of the petitioners for settlement of the subject land was considered strictly in terms of the provisions of the settlement rules framed under the Assam Land and Revenue Regulation 1886 and the Land Policy 1989, which was directly to be considered by directly to be considered in the judgment and order dated 18/7/2001, passed in Civil Rule number 1433/1996 and reiterated in the order dated 25/4/2013, passed in WPC number 7692/2005. Full stop. It is further contended that the subject plot as per the CITA records of 1968-69 was reserved for pond, quote unquote, and quote, bank of ponds, unquote. And therefore, such lands reserved for public purpose, are not to be settled in favor of individuals. And in support of such submission, a reference has been made to Rule 18 within bracket 2 of the settlement rules. Poster. To the Learned Council appearing for the state respondents have also referred to the provisions of Rule 15 and 16, Rule 16 of the settlement rules, in addition to the rules referred to by the Learned Senior Council appearing for the petitioners. First off, it is further contended on behalf of the state respondents that At no point of time. At no point of, in this writ petition. At no point of time. It has been pleaded on behalf of the petitioners that they are landless persons. Full stop. All the petitioners herein are sons of one Abdul Aziz. And when an inquiry was made by the circle officer, the Oka Revenue Circle, it was found out that the family of the petitioners owned how much land? Hmm? 9, 11, 14, 15, 18, 19, perhaps 24. 24. 24.08 bighas in the same village, that is Paschim Juroni. And the said fact was duly brought to the notice of the respondent number 1 prior to the decision taken by the impugned order dated 29/9/2014. Full stop. It has been contended that during their long occupations, the petitioners were only paying Toji Bahira which is a form of penalty for encroachment, and thus it can be it is clear that the occupation of long occupation claimed by the petitioner of the encroached subject land was only by way of encroachment. Full stop. When as the family of the petitioners had periodic patta lands in the same village, the fact that the family of the petitioners had owned would disentitle the petitioners to claim for any settlement of any government land, more particularly the subject land which is reserved for specific purposes. Full stop. Even it is assumed that at the time of making the application, the family of the petitioners did not own any land, the subsequent developments as regards owning 24.08 bighas would entitle the petitioner would disentitle the petitioners to make any claim for settlement of any government land, as the land policies are meant for distribution of wastelands, etc., only to landless persons. Full stop. Para. I have given due consideration to the submissions of the Learning Council for the parties. And I have also gone through the materials brought on record by the parties through their clinics. Full stop. Para. As already noted above, the subject plot of 7 bighas one katha 17 lasas comprises of 2 parcels of land. That is, an area of 3 bighas, 3 kathas, 5 lasas in Dag number 120. And another area measuring 3 bighas, 3 kathas, 12 lasas in Dag number 121. Both the parcels of land are in village Paschim Juroni, Moja Namoti. As per the Chita record, pertaining to the year 1968 stroke 1969. The first parcel of land in the class of Panitol are reserved for pond within bracket Pukhuri, and the second parcel of land shown reserved for bank of pond Pukhuri Park. Both the parcels of land are government land. Both of the said fact has been the said Chita, the facts recorded in the Chita has not been controverted by the petitioner, has not been traversed, so controverted by the petitioners in any manner in their pleadings. Full stop. Para. As per the settlement rules, rule 1B, 1 within bracket 2B, and 1, 2F of the settlement rules have defined quote unquote wasteland and quote unquote settlement respectively. Wasteland means so and so, settlement so and so. by Rule 2 of the settlement rules, power has been provided to the Deputy Commissioner, Jurisdictional Deputy Commissioner to dispose of wasteland required for ordinary or special cultivation or for building purposes. And the Deputy Commissioner is required to dispose of such land by grant, lease or otherwise in the manner and subject to the conditions set forth in the rules. Full stop. Rule 5 has provided that an application for leases of wasteland shall be in writing and shall be presented to the Deputy Commissioner or to such other empowered officer. Rule 8 of the settlement rules so and so has provided under 8 or good 8 no to us. Rule 15 of the settlement rules has enjoined that no person shall have any right to settlement merely because he is in occupation of land not included in any lease granted by the state government, either to himself or to any person. A prohibition is incorporated in Rule 16 of the settlement rules to the effect that the lease shall be issued on written application only, and no person shall enter into possession of wasteland in any area until a lease has been issued to him or otherwise a written permission by the Deputy Commissioner has been granted to him, pending issue of such lease, to enter into possession. As per Rule 17 of the settlement rules, if an occupant to whom settlement is offered accepts it, he shall be liable for payment of the revenue assessed on the land. A reading of Rule 16. Of the settlement rules goes to show that no person can enter into possession of any government in any area until a lease has been issued to him or otherwise, comma, a written permission has been granted to him by the deputy commissioner, comma, pending issue of such lease, comma, to enter into possession of the government land, full stop. When a person enters into possession otherwise than as per the provision of Rule 16 of the settlement rule, comma, then such a person can only be termed as an encroacher. Rule 18 of the settlement rules are also of import and relevance in the case in hand, full stop. By the Assam Land and Revenue Regulation, within bracket Amendment Act, comma, 1997, comma, sub-rule 2 of the Rule 18 has been amended, and it was published in the official gazette in its issue dated 29/3 to 1997, full stop. For ready reference, the relevant parts of Rule 18, for ready reference, Rule 18(2) are extracted here and below. Where? A plea has been taken on behalf of the petitioners that right from 1985, the petitioners are paying revenue in respect of the subject plot. And to support such claim, comma, a number of revenue receipts have been annexed to the petition as annexer A1 to A3, full stop, on a bare look at those revenue receipts goes to show that the petitioners are paying Tozi Bahira in respect of the subject lots from the year 1985. Full stop. The collection, which is made as Tozi Bahira, is in the nature of a penalty. First of the change of nomenclature from Toji Bahira to Bedokoli Jorimana within bracket encroachment penalty came in the year 1992 by a decision of the state government in the revenue department. Full stop. Para 18 of WPC 6230/2017. Para. Note Rule 18, Rule 8, sorry, Rule 8. Has provided as as extracted above, has provided for disposal of application for settlement, and has also provided for the manner in which applications are to be prioritized. Full stop. When settlement is to be given to individuals, the area should ordinarily be limited to 8 bighas to 12 bighas per family, according to the fertility of the soil. full stop. In giving settlement to individuals, comma, preference shall be given first to the settlement holders who have been rendered landless due to flood, comma, erosion or earthquake, or due to requisition or acquisition of their land by the government for public purposes. Semicolon. Secondly, to landless cultivators and displaced persons from Pakistan who are landless cultivators, semicolon. And thirdly, to cultivators having less than 8 bighas of land, full stop. The note appended to Rule 8 of the settlement rules are of pertinence. Notes. Note 1 has clarified that a person who holds less than 8 bighas in his name or in the name of any member of his family shall be eligible to get settlement of only so much of land as shall, comma, together with his existing holding, comma, not exceed 8 or 10 bighas, comma, as the case may be, full stop. Note 2 has clarified that the size of the family should also be taken into consideration in giving preference as also in determining the area to be settled with persons of the same category. Full stop. Para. At a time, the judgment and order dated 10/7/2001 in civil rule number 1433, 1996, and order dated 25/4/2013 in WBC number 7692/2005 were rendered. The policy, land policy, which was in vogue, was the land policy of 1989. Post of both the direction was made in the said two orders was to consider the case of the petitions as per the then existing land policy, which is the land policy 1989. Full stop. The impugn order, when the impugn order was passed on 29/9/2014, the land policy 1989 was in currency. Full stop. Para. As per the land policy 1989, land at the disposal of the government for ordinary cultivation may initially be given by way of allotment to indigenous landless persons. Full stop. The maximum limit of land for allotment to an individual is fixed at 7 bighas for agriculture and 1 bigha for homestead. Full stop. In the as regards giving preference, other than the 3 categories mentioned in Rule 8 of the settlement rules, few more categories were included. So those were local no, landless cultivators with preference to scheduled tribes, scheduled caste, and NOBC communities and landless ex-servicemen. Post of. It has been made clear that allotment and settlement of land for ordinary cultivation in rural area may be given on the basis of a family. It has been specifically provided therein that a family consists of husband and stroke wife, comma, as the case may be, comma, and sons and daughters, within bracket, excluding married sons and married daughters, bracket close, comma, and dependent parents, full stop. The area of land to be allotted or settled with a cultivator family having land measuring 3 bighas or less shall be so much as will, comma, together with land already held as owner or tenant or both, comma, not exceed 8 bighas in total. First of all, allotment, stroke settlement of land for ordinary cultivation will be made to the indigenous landless cultivators. In the judgment and order dated 18/7/2001 Supra. This court directed to consider the application of the petitioner, treating the recommendation of the Land Advisory Board Hojai, recommendation dated 12/1/1996 of the Land Advisory Board as valid and operative. And thereafter, to pass a final order in a matter of claim of the petitioners for settlement of land, subject land, in view of the then existing land policy of the state government relating to settlement of the land, full stop. It was further observed that the decision to be taken must be supported by adequate reasons in writing. And if asked for, the petitioner shall be provided an opportunity of hearing. Full stop. Para. In the order dated 25/4/2001, 13, comma, the court took note of the stand taken in the counter affidavit of the state respondents. wherein it was asserted that the petitioners and their family were not landless persons as they possessed periodic pata lands in the order dated 25 for 2013. Paragraph 12 of the counter affidavit was extracted, which read as under page 44, A to A. Para, in the counter affidavit in opposition filed by the respondent number 1 in the instant case, the details of the lands recorded in the names of these petitioners, these 6 petitioners, have been mentioned. First of, contrary to the area of land measuring 40 bigas, 3 kathas, 17, stroke 17, 1/4, lessas of periodic pata land claimed in the counter affidavit in WPC number 7692/2005. The respondent number 1 in the affidavit in opposition file in the instant case has averred that an area of land measuring 24.08 bighas located in village Posim Jaroni stood recorded in the names of the petitioners. Subsequently, after the death of their father, Abdul Aziz, by way of inheritance. Full stop. From the affidavit in reply of the petitioners, in the affidavit in reply, it is mentioned that Abdul Aziz expired on 26/11/2015. And prior to such prior to 26/11/2015, the petitioners were landless and they had no periodic pata land in their names. At a time when Land Advisory Board recommended for settlement of the subject land in their favor. Full stop. Para. From the copies of the Jama Mandis annexed to the affidavit in opposition of the respondent number 1, it is noticed that by way of different orders passed in mutation cases, all dated 22/4/2016. an area of land measuring 24.08 bigas stood devolved upon the petitioners by way of an inheritance from late Abdul Aziz, who was the petitioners, who was the father of all the petitioners, all the 6 petitioners. Full stop. The land policy 1989 was framed repealing the earlier land policy 1972. Full stop. The about purpose of the land policy was to dispose of, was to allot lands which are scarce, to cope with the needs of the people and to meet the requirement of the indigenous landless persons. First off, in the rural areas, if a family is having land measuring 3 bigas or less, then the allotment is to be made limited to 8 bigas in total, including the area of land already possessed, owned by the family. Full stop. It is not the case of the petitioners that it is not a pleaded case of the petitioners that at the time of making the applications for settlement of the subject land, the family of the petitioners was landless. Full stop. The judgment and order dated so and so, and order dated so and so, supra, had directed the respondent number 1 to consider the application of the petitioners for settlement by taking into consideration the recommendation dated so and so of the Land Advisory Committee, हो जाए, and without any further condition, without any further restriction. Full stop. Therefore, the respondent number 1 was required to consider the without and as per the land policy then involved. Full stop. Therefore, comma, the respondent number 1, while taking the decision for on the application for settlement of the subject land in favor of the petitioners, was required to take into consideration the recommendation of the Land Advisory Board हो जाए and the Land Policy 1989 into consideration. First off, the Land Advisory Board, as per the Land Policy 1989, comma, the Subdivisional Land Advisory Board Land Advisory Committee board no Land Advisory Committee Land Advisory Committee is only an advisory body, meaning thereby its recommendation is not binding on the respondent number 1, full stop. But it is obligatory on the part, it was obligatory on the part of the respondent number 1 to take into consideration the overall objects and purposes of the Land Policy 1989 and the and to consider the application for settlement on its own merits, including the recommendation dated so and so of the Land Advisory Committee. Full stop. As noted above, it is not the pleaded case of the petitioners that the family of the petitioners who was landless either at the time of application for settlement, either on the date of submission of the application for settlement or at the time of taking the impugned decision on so and so 28/9/2014. Full stop. On the other hand, it has been pleaded that their long and continuous possession of the subject land measuring 7 bighas, 1 kathas, 17 lessons since 1985 had repinned into the title in favor of the subject land in favor of the petitioners. Full stop. Such a claim would be in the nature of an adverse possession against government land in respect of government plot. Full stop. Merely long period of possession does not results into any right of adverse possession and right of a governmental land resting with the state right over land resting with the state cannot be claimed by any encroacher resulting in crystallization of adverse possession in a writ petition. First of para. It is it is also settled that merely by submission of an application for settlement, no vested right is created in favor of any party. Full stop. The recommendation dated 12/9/1996 of the Land Advisory Committee might have given rise to a legitimate expectation for the petitioners. But such legitimate expectation is limited to a consideration of the application in terms of the direction made in judgment and order dated so and so and order dated so and so, which in turn was considered which should amount to which should in turn for consideration of the application on its own merits and as per the land policy invoke, as it is found that the family of the petitioners was already family of the petitioners through their father is owner of periodic pata lines measuring so and so in the same village, the claim of the petitioners for consideration of their application for settlement of the subject land as landless person would cease as soon as their family through their father Abdul Aziz became owners of the parcel of land measuring 24.08 bighas, periodic pata lines measuring so and so. Full stop. It has been urged on behalf of the petitioners that at the time the impugn order was passed on 29/9/2014, the petitioners were not owning any land in their names. But they have not denied that as on 29/9/2014, their father Abdul Aziz did not own the parcel of land measuring 24.04 because in the same village, either at the time of filing the writ petition or in the affidavit in reply filed after filing of the affidavit in opposition by the respondent number 1. Full stop. Since even it is this code is of a consideration, even if at the time of submission of the, even if it is assumed that at the time of submission of the application by the petitioners, for consideration of their claim for the specific plot of land measuring so and so, that is a subject plot. The family of the petitions did not own any periodic patta land, comma, the subsequent ownership of 24.04 bighas of periodic patta lands in the same village would extinguish any claim of the petitioners for settlement of the subject land. Full stop. As the matter of settlement of land in terms of the public policies framed by the state government, including the land policy 1989, is for the purpose of giving sakar, is primarily for the purpose of giving sakar to landless persons. And the element of public interest is to be kept in mind for settlement of scarce wasteland at the disposal of the government, comma, the subsequent events, if the ownership of 24.04 bighas of periodic patta lands is accepted to be a subsequent event, then also the public element and the public policy as regards disposal of scarce wasteland at the disposal of the government for settlement would prevail over the individual claim of the petitioners. Law is settled that subsequent in a writ petition, comma, subsequent events which have a bearing on the claim of the petitioner can be very well taken into consideration, and for taking a decision, comma, when public interest stands pitted against private interests, it is always the public interest which is to be given precedence. First of para in view of the discussion made above and the regions assigned therein, this court does not find any reason, not to speak of any good and sufficient reason to interfere with the impugn order dated 29/9/2014. Full stop. Consequently, the writ petition is found to be bereft of any merits and is liable to be dismissed. It is accordingly dismissed. The state respondents, as observed in the impugn order dated 29/9/2014, the state respondents are at liberty to take the necessary steps as per the prescribed procedure for eviction of the petitioners from the subject land forthwith for retaining the land for public utility, public purposes. Para in view of the judgments and in view of the order passed in the connected writ petition, the interlocutory application does not require any consideration, and the same stands accordingly disposed of.
Your Honor, Lordship, I just have one request. Instead of my name, Mr. JP Sharma sir's name.
Mr.
recorded. JP
G.
Sharma.
JP Sharma.
Yes.
And Begumot Height, JP Sharma. Oh, yes, no repetition. Not usable. Just a minute, Mr. Chaudhary.
Malum.
Two repetitions, right?
Malum. The second repetition has in fact a very interesting history.
No, before interesting history, before I learn. As the cause list goes, I should not take up the matter. In item 2.
Item 2.
Are you in urgency?
This matter has been pending for a very long time.
But unfortunate for me.
Your Lordship was associated with this matter in some.
Not associated, somebody is associated whose case should not be taken up by me. Release the case before any other offense of me.
Lordship, Lordship.
Release the cases, right? Cases. Yes, it will go. I should have passed the order at 10:30.
I had no idea.
I missed the idea. I missed it.
I had absolutely no idea.
Items 5 and 6.
Here, Lordship, I pray for some accommodation, Lordship, next
Which for the petitioner? Okay. Anybody? There is no representation on behalf of the petition on call. Mr. S. Roy, learned.
Second to be as
CGC or government?
Government, Lordship.
You are for the petitioner?
Sorry.
Miss.
I'm taking.
Your name, please. Good name.
Mitti Das. Mitti Das.
M. Das.
M. Das.
M. Das. Learned counsel for the petitioner is present. Mr. S. Roy. I'm not going to pass any adverse order against you. Learned Junior Government Advocate.
Lordship, on behalf of D Nath, PWD law.
Okay, Learned Counsel on behalf of Mr. D. Nath, Learned Senior Government Advocate, Assam, has paid for some accommodation. Our Ms. G. Hajorika, Standing Counsel, Revenue Department, are present with you. As sought for by Mr. Roy, release the case after 2 weeks.
In Lordship.
But it is 2020.
Lordship.
Mr. Roy has sought for listing of the case after 2 weeks. Post of the praise allowed, release the case on so and so. Even
28 May.
28 May episode. Answer, not 20.
Oh,
Mr.
4 June.
Lordship.
4/6.
Cases, huh? Cases. What is the case about?
Lordship, they have filed affidavit proposing that the equal quantity of land shall be given to me, and I have an instruction to accept the proposal, but there is subject to it has to be a prime condition, prime location, and before passing any final order, there may be joint verifications for identification of the land.
I don't know whether it will be prime location or
that-
nowadays it is difficult. You arrive at a decision. We are not entering into that.
I'm just praying that Lordship, the Water Resource Department and the other respondents who are interested in the petition.
Yes,
they may be-
Mr.
No, Lordship, I'm not in this case. In fact, irrigation is made a party, but not a, but Lordship.
Now, who has filed this affidavit?
Water is
Water Resource Department.
Water Resources.
Water Resource-
Department makes the council is proposing. Chief Engineer Water Resources.
Your Lordship,
Allowed equivalent portion of land to the petitioner.
Oh,
Second.
yes.
Para 5.
para 5.
Your Lordship, my senior is on her way here.
On way.
She's
Let him come. What kind of? Oh, madam.
Lordship, my submission is. that-
Yes, any favorable land in the
Actually,
prime location.
actually, we wanted to compensate that way, but then he is not agreeing. He said, first,
Prime location.
No, earlier I had. a
actually proposal
instruction-
is also sent. Apni question?
Lordship, that
Or
I-
if you
Question?
have parted with possession of 2 bighas, take 3 bighas somewhere.
Lordship.
It is not easy to find land of equivalent area in a prime location. Maybe. I'm not saying I have not looked into this. But instead of say 2 bighas in semi-prime location, you take 3 bighas if they offer, or 4 bighas.
Lordship,
Try to
that-
also adjust that way.
Lordship negotiated.
If you want in fancy bazaar, who can give you?
Only
Neither the central government nor state government can give you.
within they are proposing
So,
within the
find
village.
take a reasonable decision.
Lord-
Or if this is the situation, then we can put it on mediation also. You can negotiate. What do you think?
That can be.
Then your petitioner will be in person. This chief engineer will be in person. They can decide this, the district administration should be
Yes.
a party. What do you think? Well, we cannot be in the bargaining thing.
Lordship,
You bargain there,
Lordship,
negotiate,
Lordship.
work out a solution,
That can be done, Lordship.
right? Yes, Ms. Chakraborty,
Minor can.
mediation চলি আছে নেকি এতিয়া প্ৰচেছটো?
নাই, নাই.
এনে mediation পাৰি.
Special drive is not on.
No, otherwise it is possible. Let both the parties try.
Lordship.
Mr. FJ Mojumdar, learned counsel for the petitioner. Miss Z. Bordoloi, Hajorika, Standing Counsel Revenue and Disaster Management Department, Mr. J. Hendik, Learned Junior Government Advocate for the respondent number 1, 2, 2, 3, and 4. And Ms. P. Chakravarti, Learned Standing Council. Water Irrigation, Mr. N. Upaidhyay, Learned Standing Council, Irrigation Department for the respondent number 5. And Ms. P. Bordoloi, Learned Standing Council, Water Resources Department for the respondent number 6. It is the case of the petitioners that an area of land measuring how much? Measuring how much?
1 giga, 1, Lordship.
Tell me the correct position.
Petition for 20. 1 biga 3 kata.
1 biga, 3 kathas, comma, belonging to the petition, comma, had been utilized by the respondent authorities in the Water Resources Department
Lordship.
for construction of an embankment.
Lordship. Now it has become a PWD road.
Stroke PWD road. Full stop. In the affidavit in opposition of the respondent number 7. Okay. Some amended cost title or what? Oh, just a minute. Oh, okay. N. Upaidhyay, Irrigation Department for respondent number 5 and 8. And Ms. P. Chakraborty, Standing Council, Water Resources Department for the respondent number 6 and 7. In the affidavit in opposition of the respondent number 7.
5, 6.
Comma, it is averred that the department is in consultation with the district commissioner Kamrup Metro for allotment of an equivalent portion of land to the petitioner in the same village in lieu of the land that has been used by the department for the greater interest of the public in the locality. Full stop. Para, it is submitted by the Learned Council for the parties that the parties have not agreed as regards any parcel of land till date, despite rounds of discussion. Full stop. In such backdrop, this court is of the considered view that the parties can explore the possibilities through mediation, through the mediation process. Full stop. On being proposed, the Learned Council for the parties have agreed to explore the possibilities of an amicable settlement through the mediation process. Full stop. Therefore, the matter be placed before the mediation center for appointment of for engagement of a mediator. Post of the parties shall the petitioner, the parties shall appear before the mediation center at 11 a.m. on. The petition is from which place, Mr.?
Is from Sonapur.
Sonapur. Okay. 25th May,
Lordship.
25/5/2026. Post op. The respondents shall ensure that they are represented by officials who are competent to take an appropriate decision in a as regards the subject matter involved in the writ petition. Right? Full stop. Lays the case immediately after the closure of the mediation process. It may be failure. Let us try. Sometimes it happens. Closure of the mediation process through the immediately after submission of the report of the mediator. Report of the mediator.
Item 8.
Okay, sorry, Medhi. Yes, Mr. Doctor.
See, here Lordship, issue is whether the state can occupy and utilize the private land without acquisition and paying compensation.
Disposes a petition and constructed a canal.
My lord, may I please continue?
What is the stand of the respondents?
Lordship, our stand is, Lordship, the land has been donated by his father, Lordship. That is our stand, Lordship.
Then, if that is not admitted, it will be difficult.
My lord,
Disputed question.
my lord, they have said, my lord, land
If
was
that is a
donated.
stand, consistent stand taken,
Lordship.
My lord, there was no, my lord, document of any instrument of that sort.
right. It is at the same time, Mr. Doctor, when it was
Yes.
utilized.
My lord, they are saying that.
Now,
they
when
have- Lord,
this land, if they say was donated by your father or your grandfather?
My father,
Father.
Your father. In which year?
it was in the year
87.
1987.
87.
1987. When did your father die?
My lord, my father died, my lord. Lordship, date I have not mentioned here, my lord.
But you know your father's date.
Yes, yes,
Obviously.
yes, and
You cannot claim ignorance.
no, my lord, what I am saying, my lord, actually, my lord, I need an accommodation for today, my lord. Because
Basic facts I am asking.
Yes, yes. My lord, regarding the date of dates, my lord, I have not mentioned in my petition.
And otherwise, they claim 1987.
Lordship. Lordship.
Donate
Lordship.
or gifted, whatever.
Lordship. Lordship.
And this land, they are there under their uninterrupted possession since 1987, as per their statement.
Yes, yes.
The factum of death of your father is very relevant.
Yes, yes.
And
That
next
information, that certificate. I
is we need three factors. Firstly, now they are disputing, they are saying gift. That is one. Their claim is that 38 years back, the owner of the land was the father when this petitioner was only 14 years of age. 1987. Now you are aged how much?
My lord, at present, my lord, my age is, my lord,
87. 1991, you became major. 25 plus 9.
52. Yes,
25
now
plus 9,
53, Lordship.
34 years.
at present,
You-
I'm 53 years.
53. 34 years.
Lordship.
You are sitting tight.
Lordship.
You were 14 years at that time.
Lordship.
You became major in 1991.
That is true.
Since 1991 till 2025, you did not file any writ petition. Or did you file any writ petition?
No, no.
No. Now, the main factor will be your father's death. Father's death. And there is settled precedent of the Supreme Court in a matter of such nature.
But my lord, the illegal occupation.
I can readily recollect. So that is why I am asking you.
Well, illegal occupation, my lord, without.
Illegal occupation, maybe that cannot be all the case. The abnormal delay. What do you do? What do you do for living?
Cultivator, my lord.
Cultivator. Your father was a cultivator, right? And if it was in hostile occupation since 1987, anything in between you have done?
Lord, that
Any
is-
alacrity
Lord, that was.
shown from your side or your father's side?
Lord, that is not there.
I
But
can
the
rightly
case-
recollect at least three decisions of the Supreme Court in a matter of such nature. But it is for you to do the homework.
Lord,
I'll recollect and put it in the order when I dictate the order.
Lord, you may give me some time.
So you tell me on the next date, what is the date of death of your
Yes,
father? M. Dotto for the petitioner and Upadhyay, Likhi Bhagavatam. S.S. Roy
6 and 7.
For a state respondents to give are present. Post of Mr. Dotto, then the counsel for the petitioner has sought an accommodation to apprise this court about the date of death of the petitioner's father. Post of. And prayer is accepted, lays the case on so and so.
2nd June,
All right.
26. Items 9 to 12.
May it please your lordship. Lordship, these matters pertain to denial of remission. With respect to item 12, lordship, the coordinate bench has passed a order yesterday. It pertains to non-consideration. Items 9 to 12, lordship. 12 pertains to non-consideration of the case completely. So a similar order has been passed yesterday, lordship, that has not been uploaded as yet. Direction was passed to reconsider with a speaking order.
And what about
As regards
in 12, counter has been filed?
In 12, counter has been filed by the respondent 6, lordship.
Who is respondent with 6?
Inspector General presents.
Okay.
Home Affairs is required, Lordship. The response of Home Affairs is required.
In the sense, there's no substantive.
What is the substantive sentences these petitioners have spent?
Lordship, between 19 to 22 years, all of them.
Mr. Roy, why you are not
Lordship, received the
leader of 2025, 9, 10 and 11?
11, 19.
Proposals, lordship, are of 24. Proposals were sent as far as I guess 24.
Otherwise,
It should be faster.
First, Lordship, otherwise,
least.
Lordship, the minute take.
I can understand non-payment of contextual bill.
Understand, Lord. The minute.
Don't take same lethargy in this kind of matters.
Lordship, the minutes of Lordship is of 1903. 1903. That's why, Lordship.
Huh?
Lordship, so
They have spent 19-20 years.
Lordship, the minutes that passed Lordship 1903 rejecting all Lordship. This is
19-3?
1903-2026. That's why Lordship.
if I may give some context, lordship, after this writ petitions were filed on 19/3/26, the committee meeting was convened of the review board. Thereafter, certain cases were considered. And the numbers are given, but the names have not been given. That lordship is the minutes before your lordship. That has been placed in the other case, which was disposed of yesterday.
What are the propositions to be taken into consideration in a case of such nature?
That is covered by a office memorandum of 6/10/2015. It lists.
Is it part of the petition?
Yes.
Yes.
And any authority?
Yes, Lordship, there is a recent judgment of the Supreme Court where it has been said that firstly,
Side that give the decisions.
yes, Lordship.
Is 32 plus 52 include your proposals?
Lordship, only with respect to item 12. Items 9 to 11 are cases which have already been rejected previously. They have been deferred, not rejected, Lordship. So those are specifically under challenge. In respect of item 12, there was no decision ever communicated. So I have just challenged the non-consideration.
In 9, 10, 11, Lordship, it has been deferred.
They have been deferred, Lordship. I've challenged the.
Whether on 19/3/2026, the cases of the petitioners in 9, 10, and 11 were taken on board.
That way, Lordship, I have to take that instruction whether this was also taken into consideration or not. By this minute, it cannot be said, Lordship.
Okay, take the get the information. We'll try to take it up again on next week.
Lordship.
Which is para 17 of the decision.
Okay. Let him take the instruction whether these cases of the petitioners are taken on board or not on 19/3/2026. That is 9, 10, and 11. Then come up with instruction. Thereafter, we'll go. Proceed to consider all the petitions
yes, very well.
required or only 12.
Lordship.
Heard Mr. Atreo,
Yeah.
A. Atreo, learned counsel for the petitioners. And Mr. S.S. Roy, learned junior government advocate for the state respondents. Full stop. Mr. Roy is to take instruction whether the cases of the petitioners in WPC 9, 10, 11 bracket or naam kita di bole naam kita bracket or bhasa se to sama were considered in the meeting of the review board in connection with premature release release on remission of life convicts held on 19/3/2026. And to place the same on the next date of listing. Post of place the cases on 14/5. Okay, this is part of which? Is it part of this?
No, other.
14/5. Aji kitagi. Oh, sorry. 14/5 is not. Sorry, 21st. I'm sorry.
Item 13.
With the order dated 7/4.
We supposed to produce the case diary in connection with Dispur PS case number
yes,
34 of 2025. Lordship, we make communicate to the police authority, but today the there is just
Okay.
swearing ceremony. So
They were busy. They were busy in law and order. So many dignitaries. R.K. Batra, Learned Counsel for petition is present. Mr. H.K. Hazurika, Learned State Council, representing the respondent number 1 to 4, has submitted that in view of the present situation resulting in the he has sought referred to the situation prevailing in the preceding week and has sought for a week's time
Lordship,
to obtain the
case diary.
case diary and the status report in reference to the order dated 7/4/2026. Postal is the case on. After week, did you?
Highly always.
Other cases.
28/5. 28/05.
28/5 one need to most of you nine.
28.
Company petition. Most of you will be nine. Get on. Melata did you? I got you 26 diok.
26.
Obliged.
Madam Soikia, Yes, whether can be, then today, you please excuse me. The case can be disposed of in a similar manner.
Similar.
Okay. Today, you please excuse me. We'll put it in your presence.
My learned friend has some objection.
Okay, okay. No, if you have any objection, I am not disposing of today.
The objection.
Miss Bormon has agreed that similar order can be
Otherwise,
passed.
yes, similar order can
Mr.
be.
Borpujari, whether regarding some interest.
Interest.
Absolutely, no difficulty, nothing. But my lord, I am on the locus, my lord, only to that extent, locus. Because this person, Pradeep Saha, who appears to be the petitioner out here, is the constituted attorney. And the orders that had been annexed to the writ petition is pertaining to some other person, my lord.
That is different case.
Exactly.
He got the power of attorney on behalf of the petitioners.
No.
Petitioners,
Borpujari,
not literate.
so original Jotedar or whatever, or Khatian or tenure holder
Tenure holder.
is one or the same or not?
That there is also, my lord, discrepancy to that effect.
Huh?
There is also discrepancy because
Power of attorney may be different. It can be changed at different point of time. Whether original tenure holder, name of the.
documents annexed to the writ petition, my lord, do not depict the genealogy. Even
So what kind of clarification do you require?
my lord, clarification to the
In a
extent
discrimination in the spelling or the name itself?
name itself.
Tell me what is the discrepancy? I am not opening the file. I am just asking.
Yes. Now, paragraph 2, if lordship
Just
bears
the name.
for 1 minute, my lord, only. Paragraph 2, my lord, the ex-tenure holder, due to some personal difficulties, appointed the petitioner as attorney holder. Now, my lord, lordship will kindly see, my lord, who are
That is
the
Pradeep Saha.
yes. Now, my lord, who are the ex-tenure holders that, my lord, one order has been annexed because at the time of determining the
No,
compensation.
he is the, as per the power of attorney, he is the constituted attorney of which
Yes,
person?
constituted attorney of one Azam Ali.
Azam.
Azam Ali.
Okay.
One Azam Ali. And Azam Ali claims to be in the power of attorney itself, my lord. It has been written that Azam Ali is the legal heir of one Saheb Ali. Now, Saheb Ali was actually the ex-tenure holder who owned and possessed the Zot land in so and so. As per the constituted attorney, I'm going by that my power of attorney document.
So,
Now,
any document linking Sahib Ali with
Yes. Yes.
Ajab Ali?
there is a missing link. Now,
That Ms. Sokia will provide
yes.
My lord, it is.
birth certificate,
Well,
the
the petition-
matriculation admit card, anything.
But
Or Aadhaar.
It is
then
my
I
lord,
will,
six-
my lord, immediately I will.
Ms. Sokia, do it.
Gazette notification is of my lord 1966.
Well, either Aadhaar card will do, Epic card will do, birth
Sahib Ali.
certificate will do.
Sahab Ali.
Otherwise, again, we'll have to take objection to record his
To that
objection.
extent.
Only the Aadhaar card will do.
It is my lord verified.
We are not concerned with
Compensation. officer
attorney.
verified.
We are not
Yes.
concerned with attorney.
No, I'm not. on-
Our interest is that if interest is entitled
Yes.
to the tenure holder, it must go
to the
in his favor,
Yes.
and I'll direct that in his account.
In his-
No issue.
Yes,
Just give a linking document.
that much. Only that much.
Ms. Sokia,
Yes.
Only
just
that
give a
much.
linking document that any Aadhaar
Present-
card, date
present-
of birth, matriculation admit card, even the Epic will do.
That much. Otherwise, once
If he
that-
is not a deleted voter in a SIR or what.
Now, my lord, if
Madam Sokia, do it.
66, my lord. That's why, my lord, the present,
No, no.
he will be.
No, this man.
Present Parnimat only. Even.
No, not Pradeep Saha. What is the name? Ijab Ali.
Not produced.
Saheb Ali.
Huh?
Saheb
Ali.
Ali was the
His father,
original.
Yes, Saheb Ali was the original ex-tenure holder.
Yes.
whatever.
He-
Now Ajib Ali is the.
Azam Ali is the son who has executed the power of attorney in favor of Pradeep
But-
Saha, that is the
No,
petition.
any document of Ajab Ali
Yes.
wherein
Yes,
Saheb Ali is shown as his father.
so and his father. Yes,
That's all.
that much. Yes, that much.
That's all.
That much.
So Ajib Ali's Aadhaar card will do.
Yes. That much.
And that's it.
Thereupon, I will
Otherwise,
immediately succumb.
Okay. He
Immediately.
will succumb to the injuries.
Yes.
No, absolutely not.
I already.
Succumb to the
My lord, I'm
Succumb to the Aadhaar card. Okay, that information.
My only endeavor, my lord,
Okay,
is that
heart
the
miss-
money should flow to the right hands, my lord.
Are you in contact with Mr. Counsel?
Yes.
Are you in contact with your client or not?
Yes.
Get the Aadhaar card of the petition.
Yes. Here, my
Must
lord,
be having
the
an
power
Aadhaar card,
attorney holder.
not Pradeep Saha.
Yes. Sahab Ali, external holder and owned by Pradeep.
Please give the spelling. I had Mr.
Yes.
N. Soikia, learned counsel for the petitioner. Mr. R. Borpuzari, learned standing counsel, finance and revenue.
Revenue.
Both
No, here I'm only for
are
revenue.
revenue. What problem? Are you a finance also?
Finance also.
That will do.
Yes.
Revenue and finance department. And Miss M. Bormal, learned junior member for the state, Assam. For the respondents. Full stop. Para. Mr. Borpozari has submitted that from the pleadings in the repetition and from the pleadings in the repetition and documents annexed thereto, comma, it is not demonstrated that Mr.
One Saheb Ali SK. Saheb, S-A-H-E-B.
Son's name.
Saheb Ali SK was the ex-tenure holder.
Sikh.
One Saheb Ali SK was the ex-tenure holder.
And his son, namely
And
Azam
his son, comma,
Only the son.
his son, comma,
and his son Azam A-Z-A-M. Z.
Z,
Azam Ali.
A-M, A-Z-A-M,
My lord.
Ali,
Ali. Azam Ali.
has claimed the interest amount.
Son.
Already said, his son, comma, Azam Ali
Azam Ali
has claimed
has executed
interest
Yes, claim interest.
through this petition.
Petition by by filing this petition through his constituted attorney.
That will do.
My lord.
কি লিখিলে ও?
If I could live, more so.
Both of you are saying so much. Huh?
Why not hang
No, it is not demonstrated by any documentary evidence that that Mr. Azam Ali, who has claimed interest as the son of X
tenure holder.
is the son of the ex tenure holder, Saheb Ali SK.
Saheb Ali, yes, I'm so deeply obliged, man. That much.
So, Ms. Soikia has sought for a week's time to obtain instruction in the matter and to clarify the said issue through an additional affidavit. First up, release the case on
Additional affidavit, my lord.
Aadhaar card.
Aadhaar card.
I have indicated.
Should I produce it or my lord? Additional affidavit is required.
Otherwise, Mr. Borpuzari will again say.
My
Next.
Release the case on.
Next.
By what time? What is expected?
Next. Because it can be sent by.
Next Thursday. Next Thursday.
So,
Photocopy will do. I need not press the original.
No.
Because in mobile they can send it, madam.
my only endeavor is that my lord, money should flow to the right hand. Only that much. Only that much. Only that much.
Sir, compulsion is there.
I'm so obliged.
মঙ্গলবার কিবা আছে নেকি পঢ় লাগিছিল আজি কিবা আজি মঙ্গলবাৰ ন বৃহস্পতিবাৰে কি আছে বৃহস্পতিবাৰে কি আছে
Yes, may I please, your lordship? Lordship, matter may be fixed on tomorrow, lordship.
কি মজা ওই তো স্টোডি কোনটো কি কৈছে এইটোতো অহা বৃহস্পতিবাৰ এই আজি 12 তাৰিখ ন Okay. Okay, day after tomorrow. Mr.
M. Hussain.
M. Hussain and Miss P. Chakraborty. B. Union of India. Miss so and so. Miss, your name, please. Your name, please.
Lordship, I'm M. Das.
M. Das. B. Chakraborty, CGC. Respondent 4. Who is the bank counsel? The learned counsel for the respondent number 1, 2, and 3 is found absent today on call. Full stop. The petition has filed an affidavit in reply and the office to incorporate the same in the index. List the case. Then index school bolego no. List the case on Friday.
Always do, Lordship.
15 May. Item 16.
Yes, madam.
Acid attack, she's an acid attack victim petitioner, all the petitioners, Lordship. The main victim is petitioner number 1, Lordship.
All three are victims.
Yes, because main victim is
Sufferer of acid attack, who is the one? All. Different incidents or what?
No, one incident, it spill over to other children of petitioner number 1.
Okay. Oh, for what purpose it has come today?
Today, Lordship, interim, this honorable court was pleased to pass an interim order, Lordship.
That as per Supreme Court direction, my lord, that recommendation has to be made on the part of DC, my lord, to the Revenue Department for additional.
Yes, Miss Ghosh, once I have passed a detailed order.
Application, Lordship.
Huh? Once I have passed a detailed order.
Yes,
In
Lordship.
your case.
Yes, Lordship.
For 1 lakh.
Yes,
Yes,
Lordship.
Who is that order? I'll not scratch my head.
Actually, on the last occasion, I have.
It is not there. Okay.
It's WPC 146/2025.
Okay. It is there.
That recommendation is ready, my lord, but due to non-signature of that Deputy Commissioner, I could not produce it today, my lord.
Okay. Can Miss Ghosh, can it be on Thursday?
Yes,
Ah.
21st.
By that time,
Huh?
probably I get that letter also, signed letter, so that it can help her
Okay.
case to recommendation, my lord.
The
The Revenue Department.
Tuesday, did you know that? Tuesday?
Next Tuesday.
Miss D. Ghosh, the counsel for the petitioner is present. Petitioners. Miss M. Burman and Union Government Advocate for the respondent number 2 and 6.
2 and
Miss S. Sharma, learned counsel on behalf of the standing counsel. Health Department for the respondent number 3 and 4 are present. Ms. Burman has sought for some accommodation in order to obtain up-to-date instruction in the matter. When it is possible for you, or
Within a day or two, my lord.
Okay.
Because today is that due to function, he could not sign
Next
that
Tuesday?
recommendation, lordship.
Next
I'll
Tuesday?
try my best.
next Tuesday, Madam Ghosh,
Yes, Lordship.
next Tuesday.
Small issue.
Huh? Okay, Monday. This
We'll
can be
try.
done. Already order is there. If
Lordship.
they don't do it, we'll pass the similar order.
Lodge.
Yes.
18/05.